As you can see, as you can see, we're not either. So anyway, thank you for joining us. If you want to just introduce yourself for the record.
My name is Judith Dillon. I'm the Executive Director of the Vermont Labor Relations Board. I've held this position for about 3 years. My predecessor was in this position for about 40 years. So he worked with the early founders of the board in developing the board and how it runs and operates, and retired after a long and distinguished career. I am the one full-time staff member of the board, and we have one part-time clerk of the board. The board administers the 7 state statutes which govern labor management relationships in the state. And the board is administered by 6 lay members. They are paid a stipend for the work that they do, $125 a day for members, and $175 a day for, $175 a day for the chair. So you're probably most familiar with the State Employee Labor Relations Act, the Municipal Employee Labor Relations Act. There are also the Judiciary Act. There is the State Labor Relations Act, which governs the few situations where a private employer that does not have any interstate contacts. That's a summary description of it, but there are a few cases involving libraries primarily where the NLRB has not exercised jurisdiction over those folks, that the board has exercised jurisdiction over entities or individuals, employees who had wanted to unionize, but they had a private employer as opposed to a public employer. All of the other statutes govern public employees, whether they be state employees, such as Department of Corrections, Human Resources, Department of Transportation, as well as UVM and our Vermont State College system. Those employees as well are governed by our State Employee Labor Relations Act. The Municipal Act governs all of our municipalities as well as school districts. So Town of Calais, the road crew members decided last year that they wanted to unionize. They were able to form a union. There are a couple of other statutes that are less known. That's the child care statute and the independent care provider statute. And those are statutes that allow care providers who receive financial assistance from the state to form independent direct support providers, home and community-based services that provide service to a recipient receiving funds to collectively bargain directly with the state. Similarly, the Early Child Care and Education Providers Labor Relations Act allows for licensed care providers, licensed care home providers, registered care home providers, or legally exempt home provider the right to collectively bargain and then pursue a collective bargaining agreement directly with the state. So that's a general overview of the statutes. I can go in more detail with respect to all of them, but I'd like to, if this would be helpful, to basically go chronologically from the petition to form a collective bargaining representation all the way to dispute resolution and where the board gets involved. Would that be helpful?
I think, yeah, that would be good. Representative Justin Tangerine.
Thank you. Just before we do that, am I correct in remembering that the early childhood education and home care providers, though they have the right, they have not yet organized?
Yeah, we haven't seen anything from them. So, yeah.
And both of them also are unique, perhaps, in being geographically. The person to whom or the entity with whom they would collectively bargain is the state. So that's different. It's as opposed to, their client or the person that they have day-to-day interaction with. Mhm.
Yes, it is. They are dispersed throughout the state. They're not, it's not, one town or one geographic region, so it's not limited. So yes, that they are unique in that respect. Although you could say, the Department of Transportation has employees throughout the state as well, but yes, they don't have a common traditional employer like you might see with a municipality or even a state or UVM colleges. If a group of individuals or if an existing union wants to form a collective group with which to bargain with their employer, they would file a petition with the board. They would file it. So let's say it's United Auto Workers. United Auto Workers wants to represent a group of individuals, and I'll use an example, UVM. They want to represent, or UVM resident assistants want to form a union. The way that you do it, I'll talk about two timeframes. One is before July 1 and one is after July 1. As you know, the statute change allowing for representation without an election, but I'll talk about generally what happens. So folks who are interested in forming either joining a union or being represented have to demonstrate their interest by either signing a card indicating we wish to be represented by United Auto Workers, or they'll name themselves as a collective to be our exclusive bargaining representative. And we recognize that by signing this card, if 50% plus one are those signing, or those who are eligible to, those persons who want to form this collective, sign these cards, then there will be no election. I'm kind of getting ahead of myself, but so they file a petition. And then the board gets involved by reviewing it. And then we immediately contact the employer. We say, hey, this group of individuals has filed a petition. Please give us a list of your employees and let us know if the unit as they've described, if you have any challenge to that unit. So I'm going to switch my example because I think it's easier. The town of Calais road workers. So the town of Calais road workers, there are 6 road workers in the entire employed by the town. 4 of them file their interest cards saying, hey, we want, IBEW to represent us. And they provide a list of employees, but we need to confirm that. So we ask the employer to send us their list of the folks who would be within that unit. So the petition asks for a description of the unit. So the description is all full-time road construction workers or road workers within the town of Calais. So the town would then say, we've got seven employees, here they are. But they might also say, as part of their response, one of them is the road foreman, and the road foreman should be excluded from this unit because they're a supervisor. And under the statute, supervisors are not employees and should not be eligible in this unit. If the folks who actually filed the petition disagree, then there'd be a hearing. And the board would get involved the board would have a unit determination hearing to determine whether or not the road foreman is indeed a supervisor, in fact. And if they are, they'd be excluded from the unit. Most of the times when there's a challenge, the parties reach an agreement. The board has had, a handful, since I've been on working for the board, has had a handful, I think 4 hearings on unit determination. They're rare, especially since the legislature made changes, I think 3 years ago, requiring a hearing within a really short period of time. It's within 10 days. Neither side, especially if you're dealing with the municipality, doesn't have time to generate they may not even have enough time to have a select board meeting from the time the petition is filed till the time a hearing is required to get their boxes in a row to prepare for a hearing. So most of the time, the parties reach an agreement. And if there's no agreement, the board has a hearing, and at the end of that, the unit is determined. Once the unit's determined, then an election can proceed. If it's a situation where there's no challenge to the unit and there's no existing union representing the group, under the new statute, if 50% plus one of the folks in the unit demonstrate their desire to be represented by the union, and the employer confirms, yep, the list of employees that the union has represented are in the unit, and the board then does the math to make sure it's 50% plus one, the board will then certify. The board has done that since July 1. I think the board has certified 3 unions through that process. So in the situation where you don't have the 50% plus one situation, there'll be an election. The board gets involved in determining and working with the parties whether they want an in-person election or a mail-in ballot election. Most of the time since COVID, most of the elections are through mail-in ballot. If the unit is small, it's not that cumbersome on the staff. Because you have, 7 to 15 ballots to get together, and it's a packet, it's a ballot packet, it's information on we're providing you with a ballot. Here are the instructions for filling out the ballot. We give them a ballot, we give them a self-addressed stamped envelope, we give them a time frame for when to get the ballot back. And we have to include a self-addressed stamped envelope. So we, collate this and we get it together and we send it out. For small units, it's not cumbersome. For a unit like, the state of Vermont Department of Corrections, like we had 2 years ago, or a UVM, we had 2 UVM elections in 2021. That it took, a week of kind of collating to generate the packets for folk to get it out, but those are rare. But it is time consuming, and we have 1.5 person people staff members. If it's an in-person election, I will go to where the parties, the work site in most cases. I've been to the town of Ludlow Garage. I've been to Hyde Park. I've been to a school, I've been to a fire station, I've been to a bus depot. So the election is in person at a time mutually agreed upon by the parties. And it's usually a time where the greatest number of workers will be at the location. So it's at a shift change, at lunch, in the beginning of the day, or the end of the day. And that the time commitment for the board is, I will, taking my time to go there, administer the election. So while I'm doing that, I can't be doing something else. And then after the election, if there is an election, if, a majority votes to, yay, we want, we're going back to our Calais example, if there's an election, let me back up. If it's a mail-in ballot election, the ballot count actually takes place at the board. We've had some live in person, like, for example, the UVM elections I referenced and the Department of Corrections election, representatives from both sides wanted to be there. But all of our mail-in ballot elections are live on Teams. I send out a meeting invite to whomever wants to watch, and I set up my laptop so that I have a ballot box, I count the ballots, everyone can see, I put the ballot up to the camera to make sure there's confirmation of, yes, we want to join the union, no, we don't. So everyone is keeping count at the same time. If the votes in the affirmative, whether it's an in-person election or a remote election, there's an opportunity to challenge the election process. For example, if it were a live election and someone's claiming there was voter influence or tampering, folks have 10 days to challenge. If there's no challenge, then the board will issue an order of certification. Once there's a union has been certified, then comes the process of negotiating a contract or a collective bargaining agreement. The parties usually are able to do that on their own and are successful. Sometimes they need assistance. Sometimes they reach an impasse. In most cases, if there's an impasse, I'll go to the state statute and the judiciary statute. If there's an impasse, the parties jointly come to the board requesting assistance, and the board will issue an order of impasse, ordering a mediation, and identifying a mediator. Most of the times, the folks know who their mediator will be, and the board will incorporate in that in their order. If it's under the municipal statute, if they reach an impasse, they go to the Department of Labor. They don't come to the Vermont Labor Relations Board. So it's a slightly different process. Similarly, there's no right to strike under, the first step is impasse, then mediation. The second step is fact finding. If after there's an opportunity to try to negotiate the terms that they can't agree to with the assistance of a mediator, if they can't reach an agreement and they dedicated at least 15 days to trying to reach an agreement, they can come back to the board and ask for a fact finder. Usually it's an arbitrator, and the board will order that as well. And if after that, if they're still unsuccessful, they can come back to the board, requesting a last best offer, which is incredibly rare. I haven't seen one in the time that I've been there. The municipal statute, there is a strike provision. There isn't a strike provision in the state, the judicial statutes.
So just meaning that in the municipal context, they cannot strike, but they can in the others?
The opposite.
The other way around?
Yeah. So you've got a contract. The next step is let's say the state of Vermont, I'm going to use the state of Vermont example. State of Vermont has a contract with the Department of Corrections has a contract with its workers. There are actually several contracts, and so maybe that's a bad example. The town of Calais has a contract, let's say, with its road workers now that they formed the union. And they have a process for disciplining, and they discipline an employee. Employee's not, that's not a good example, excuse me. I'm going to give you an example involving the state statute, because it's only under the state statute and the judicial statute where the board gets involved with grievances. A grievance is where one party, one side or the other to the collective bargaining agreement asserts that the other side breached some provision of the contract, some provision of the collective bargaining agreement. Someone should have been promoted, they weren't promoted. Someone was fired, they shouldn't have been, they did not go through the just cause process for firing them. If there's a dispute about that, the union can bring a grievance, the individual employee can bring a grievance, or the employer, the state of Vermont, UVM, Vermont State Colleges, can bring a grievance. And the board gets involved in resolving that. The board members themselves are the hearing panel that hears the grievance. Prior to that time, the folks, parties to the dispute go through a discovery process. Sometimes they may have depositions, they'll exchange documents, and then there'll be a hearing. And the board, let me back up, I'm not sure if I said this. The board consists of 6 lay members, 2 of them from labor, 2 of them from a management, and 2 who are neutral. And at our grievance hearings, we have 1 panel member from each of those groups. So we have 1 management, 1 labor, 1 neutral at all of our hearings where the board is adjudicating disputes. I assist the board because it's a lay board. We currently don't have any attorneys on the board. So I have to provide the board with education on what the statutes provide, what the standards are, what the standards of proof are, what, basic, some evidentiary background, some procedural background. And during the course of the hearing, I am there as well, but I am not the decision maker. The board is the decision maker. After hearing, and the hearing is presided over by the board chair or his designee. And after the hearing, the parties have an opportunity to submit briefing. And then after they submit the briefs, the board deliberates, and then issues a decision. Board comes up with its decision. I draft the decision for the board. The board reviews it, makes modifications. So that's a grievance. The other type of matter in which the board gets involved are unfair labor practice claims, which all of the statutes, there's a provision for unfair labor practice claims. So those are if someone, either an employee, a union, or employer asserts that, a union or an employer interfered with, failed to negotiate in good faith, interfered with someone's right to, participate in a union, interfered with someone's, duties within a union. So there's a statute outlining the unfair labor practices statute, which asserts a number of causes of action. But, kind of the big picture is to promote, good faith relationships between employers and employees. And where there's a breach of that, folks bring an unfair labor practice. And the way that process works is whether it's the employee, employer, or union, they file an unfair labor practice charge asserting an unfair labor practice. Once it's filed, I alert the employer, then oftentimes there'll be an investigatory conference where I get a little bit more information from the parties. And I also attempt to see if there's an opportunity for mediation. And so I often get involved with informal mediation with the parties. There've been a couple of cases where that's been successful. And after eliciting some information from the parties, we realize that the problem is a little bit smaller or more refined than as it was outlined in the unfair labor practice. And sometimes the parties reach a resolution, and then the party that filed the charge dismisses the charge. So it's resolved by an agreement of the parties, which is great. If that doesn't happen, the board determines whether it's a claim that's worthy of a charge, if there are sufficient facts brought to sustain an unfair labor practice complaint. If there are, the board will issue a complaint. If a complaint has been issued, a hearing will then be held. At that hearing, the Vermont rules of evidence apply. In grievances, the rules of evidence don't apply, although the board is guided by the rules of evidence. So that's unfair labor practices. I talked about impasse. I talked about grievance. I think that's pretty much the work of the board. This year, we have seen an increase in the number of petitions. So the petitions to actually form a union or have gone up. We've had 14 so far this year, and last year by the end of the year, we only had I think it was 11. I just double check my notes. We had 9, excuse me. So all of last year we had 9. As of today, mid-September, we have 14. I would imagine we'd have some more before the end of the year. So that's a trend. I think maybe the statute change might have encouraged some to file, but I know there were a couple of unions who were waiting to file until after July 1 to file their petitions, and those are the three that I mentioned. So that's kind of big picture. What we do.
So we changed the law effective July 1st. So that if a majority of the
Plus one.
bargaining unit, 50% plus one. But you can still, am I right in thinking you can still file a petition with fewer names?
Yes.
And
yes.
how does the board handle those if there aren't 50%?
The statute as existed before July 1 provided 30%. So 30% have to demonstrate interest. So if 30% demonstrating interest, we, have the unit determination question. If there's no question, then we go to an election. So the 50% plus one, it basically did away with the I'm not the legislature, but from the outside perspective, you got the majority. You got what you thought, what you would have anticipated from the election, because you need that in order to have the union prevail. So rather than have to go through an election, if you can demonstrate it from the outset. But sometimes unions can't get it for whatever reason. It may not be lack of interest. It might be inability to collect the signatures, because sometimes it's challenging to collect the signatures, and it might be easier to send out, a mail-in ballot to get people's attention, and then they could do it from the quiet of their home versus, I'm a bus driver. I'm not coming into the depot at the times when someone's there collecting signatures.
So there may still be, there's still the opportunity for elections. You still.
Absolutely. And when there's an existing union, for example, we have a situation now where one union's come in where there's an existing union relationship with a group of employees. 30% plus, at least 30% of those employees said, hey, we want this other union to represent us. In that situation, the statute that was amended does not apply. I mean, if there's a pre-existing union relationship, even if you have 50% plus one, you need to have an election.
Can you say anything about the board's capacity right now? So we're wondering, one of the considerations is, who would provide oversight if we were to expand collective bargaining rights to agricultural workers. Just under existing conditions, how constrained are you feeling? Is the board big enough? Does it have the capacity to do with what it's already being tasked to do, or is there additional room there for taking on more work?
I'll answer this by the Vermont Labor Relations Board is part of an organization known as the Association of Labor Relations Agencies, which is an organization that invites labor relations agencies from throughout the United States and Canada. And at our most recent conference in Detroit in July, I had an opportunity to talk with my colleagues from throughout the United States and Canada, and our sister organization in Alaska. Alaska has a comparable population in terms of numbers, approximately 600, give or up and down, they have challenges in terms of getting from here to there that we don't have. But they have their staff. They have 3 people working there. We have 1.5. So that's I think that the board would benefit from at least one more lawyer. I don't think this is directly what you're asking, but I want to make sure to preface what I'm saying about capacity, that I don't think our capacity constraints would be impacted by additional work from agricultural workers. I think the board would benefit from having an additional lawyer working for the board. The Vermont Labor Relations pay plan includes another position, but at some point it was cut prior to my arrival. Anyway, that's my 2 cents. So I depending upon how you structure it in terms of whether there's whether it's comparable to the childcare statute or the independent care provider statute. If it's a situation like that, where there are likely, one or, a limited number, not a limited, but, 5 to 10 possible employer entities on the other side of a collective group of farm workers. I don't think that would make a tremendous difference. It sounds like it might be more akin to, in terms of numbers, it wouldn't be larger than the number of municipal petitions that are filed, which are, most of what are filed. Most of our petitions are for municipal unions to be formed or switching of one union versus being exchanged for another union. I don't know that it would, how much it would add. Obviously, if we were the ones administering it, then it would be added to our workload. But, and elections are, just because of the changes that were made to the legislation 3 years ago about the timeframes for elections, because of that, they go to the top of our pile, or my work pile, because there's certain things that have to be done within a specific period of time. Whereas the other aspects of our jurisdiction don't have those timelines. And I'm not asking for them, because if they're anything like the election timelines, you'll be looking for 2 lawyers, not just one. So I wasn't very, I'm not quite sure how much more to add to that response.
Senator Cullen.
Thank you. So what would be the procedure if this group decided to have another body oversight overseas? As has been the case in 3 of the other states. There's a separate agricultural labor relations board.
So you're asking me, if it's a separate board, then it would be that board that administers
Understood.
it.
But what would be the procedure for going in that direction?
You mean, how would you
Yeah.
create a statute? I mean, I think you would,
I think we know how to do that, but I meant.
I'm not sure I understand your question. I'm sorry. I didn't mean to.
Yeah, no, that's okay. I'm just trying to figure out 3 of the other 3, I think there's 14 on the sheet. And they decided to go with, in one case, they call it the Agricultural Employment Relations Board. And then the other 2 are Agricultural Labor Relations Board.
Mhm.
So I don't know whether the states of Arizona, California, or Kansas already have a pre-existing, like we have the Vermont Labor Relations Board, and they just sort of did this other group. I don't know how many can the common people that are on one be on the other one as well, or does it normally involve different people?
Yeah, I for purposes of today's hearing, I didn't research what other
Okay.
states were doing.
All right.
But I think something about your question made me think of the farm worker exemption. I mean, there may be a case, and I'm not sure if it exists in the state, where the state may, I don't know if the state has, a state farm. And if there are agricultural workers working on a farm, I mean, I'm not thinking of the prison situation, State Farm, but if there were a park, and as part of the park, you do have agricultural workers cultivating, farm products. I don't know if that's the situation, but that would be, if there were employees that would otherwise be characterized or defined as agricultural workers that are employed by a municipality or a school or or the state of Vermont or UVM or Vermont State Colleges, they would be, I would imagine they could be captured by our existing statutes if the exemption is lifted. But if you're looking at kind of your more traditional farm situation, you know, a farm that feeds into Agrimark or whatever, then, you know, if you are thinking about having a separate board, oversight body, then they would get funneled through there. So I think there may, to the extent there may be those that overlap, that might be a problem. But I don't know if that exists. I don't know if that exists.
Thank you.
Justin Tincher?
Thank you. So following up on a different approach that Senator Cullimore, if the existing labor relations board were to also take agriculture under the purview, you had mentioned that the early childhood workers and the home care providers negotiate directly with the state.
Yep.
What entity at the state level?
I don't have the answer to that at the top of my head. I can follow up with you on that. Because there hasn't
Doesn't have to
been,
be right
yeah, I could follow with you on that, but I think, it might be, I don't know the answer. Mhm.
Just thinking, as we've talked about, a lot of small farms and small groups of workers potentially, and the costs associated with negotiation. I'm just interested in how it works with other small groups of dispersed workers.
Mhm. Yep.
Can you say anything about the board, the makeup of the board and how much turnover there is when there is an opening? Has it been difficult to find, get people to take it on?
We've been fortunate that our board members traditionally have served for a number of them, I can't say all, but you know, more than half have served for more than one term. The makeup of our board, though, all of them but one are retired and are not currently in the labor market. What our newest board member she is kind of from the management side. She currently works in human resources and is working, you know, with a Vermont employer. When she replaced our long-serving board chair, Dick Park, who worked for 25 years, who volunteered for 25 years or served for 25 years for the board. There have been times, however, where there has been a challenge recruiting folk. We currently have an opening, Alan Willard, who has served, I think, for 13, if not 15 years, I apologize. His term ended in June, the end of June, but he's continuing to serve until the governor appoints someone. I think that there was only one person who applied for his position. And there are times when it's challenging to find folk, especially neutrals. And my theory is part of it is the stipend. I think if you are working in the labor force, or if you have needs, if you have to pay for childcare, or you have to pay for someone to come into your home to provide elder care or care for a spouse or a family member, you have to leave them to come and serve for the board for a day, 1 day to 3 days per month. If you're getting $125 versus what you might have received from your job, it makes it challenging to serve. So if the goal is to have board members that are aware of the current conditions on the job, are aware of the changing nature of the day-to-day workforce, especially post-COVID, and the changes that have been made from remote working, then I think a recommendation of increasing even slightly the stipend. So it sometimes is challenging to recruit new folk. but the governor hasn't appointed that person yet, to fill, board member Willard's slot.
But the board can still meet and conduct.
Yes, and he is continuing to serve.
Oh, okay,
So
so,
on our schedule, we're scheduling hearings in the fall, and we have his replacement on the schedule, but he's going to do it if we don't have a replacement, so.
and then just thinking about the sort of the duties and responsibilities that you went through, where the board is involved. When there's an election or certification, does the board get involved or is that mostly the staff?
It's mostly the staff. The board gets involved with respect to the certification. So there's a certification order. I don't sign the order. I draft the order and I provide it to the board chair. And I provide a summary of all of the elections to all of the board members. You know, we had an election today, and here are the results. After 10 days, if there's no objection, I'll draft an order and it's available, and the board chair reviews it. If he has any questions, I make modifications, but it's signed by him. For the larger elections, the UVM election in 2021, the board actually assisted in assembling the envelopes. One of our board members was much better than the others, but so it's a note to myself on who to ask.
So the board meets 1 to 3 times a month or however often it is.
That's a good question. The board meets as a board 4 times a year for board meetings. So we, talk about, at those board meetings, we talk about outstanding cases, issues that have come up. If there's a Supreme Court decision on one of our cases, what the decision held and how that may or may not impact the work of the board and future decisions of the board, or how the board should be hearing future cases. We talk about, trends. We have a board meeting coming up in October. We're going to be talking about my desire to convert to a electronic case management system because we've been dealing with paper. So primarily, and we're trying to move it to the 21st century. So we have those, but in addition to that, the board members themselves serve on panels hearing grievances and unfair labor practice complaints.
Those 3-person panels.
Those 3-person panels, yes. And also, the board members get involved. When I was talking about unfair labor practices, there's an initial determination whether or not to issue a complaint. I reach out to the board chairs, asking that we convene a panel to review the charge to determine whether or not to issue a complaint. So the board gets involved in that as well. But a lot of times that's a remote deliberation because there hasn't been an actual hearing. So sometimes we'll do that after a board meeting, and sometimes we'll do that remotely through Teams.
Any other questions?
I'm just curious what type of time commitment there is for trying to encourage people to apply to your board.
The board chair has more work than the other members, but I would say anywhere from 1 to 3 days a month. On average. Yes.
Right. Thank you.
And they also get to go to the conference if they want to. So.
Any other questions?
All set?
Something.
All right, good. Thanks very much.
Thank
Wondering if we should invite Damien to come back to the table, and then we can talk about our next meeting, what we want to try and do, schedule that.
Should go to sit stand committee tables here. Although it might be a little weird to see the whole committee stand at the table answers, but
So we have 4 more meeting dates, I think, is the plan, the last of which could be the 15th of December, thereabouts, if I remember correctly. So then if we had another meeting, say 3 weeks from now, October 11th, the Friday, that would leave us maybe a date in early-ish to mid-November, probably after Election Day, just so that, thank you, we're not, complicating people's lives too much. And then another meeting sometime after Thanksgiving to move along. So that's sort of the general timeframe. I suggested that at our next meeting, we hear from farmers and farm workers, both of whom have asked for an opportunity to testify, and I'm sure that will be important. But do others have other thoughts on who might be helpful to hear from at this point?
Nope.
Bearing in mind that we want to, that we've been charged with ultimately drafting, legislation that answers, questions, some of which have been conveniently laid out here in this chart, I think. But what do we want this statute to look like in terms of authority, so the oversight authority, what employers are eligible, what employees are eligible. Senator Brown.
One question, and this is partially to Damon as well. There are specialists in labor law in the private sector, either through the law school or individual private attorneys. Would you suggest we get additional legal advice?
I think it might make sense as part of your hearing from folks who are in the agricultural community to see if it's possible to talk with someone who has experience in one of the states where there's active agricultural collective bargaining. I think we certainly have some very good labor attorneys here in the state. I think the difficulty is that there are a lot of differences between, say, a factory union or a hospital union and a union that's on a working farm. So I think that it certainly makes sense to hear from a practitioner who has been doing this work in another state. I don't have a good name for you. I know Senator Brom Hinsdale mentioned that she was reaching out to some national groups. It may also make sense to reach out to one of those agricultural employment relations bodies or labor relations bodies, one of the 3, to see if they have someone, either one of their staff or could recommend an attorney from their state who could speak knowledgeably. And that's certainly something I could facilitate now that I know who they are, which I didn't at our first meeting. But I think the information you'd get from folks who are negotiating in those states would be invaluable. You likely would also want to hear from to get a sort of balanced perspective, hear from someone who's both representing farmers and someone who's representing unions, because they're likely to be different people. And they can speak to the shortcomings or not of their state's laws and what they would change.
And you believe you have the ability to perhaps facilitate identifying?
I can certainly, I'm flat out and through next Friday, but certainly the following week I could reach out to those panels and just let them know what we're doing and ask them if they would recommend anyone for us to reach out to. And so I can do that. So.
I was going to along those lines, but I was going to suggest maybe someone from the, possibly the Labor Relations Board of Massachusetts. Just as we discussed last time, New England State, a lot of small agriculture, diversified agriculture, see what and hear from them what's working and what's not.
Yeah, another, sorry to cut you off. I was gonna say another resource that just sprang to mind is, I just discovered how to access old committee documents in Maine this morning, and their legislative committee. I can look at their witness list too, to see if they had anyone. Because that again could give us a few initial contacts from out of state. I'm not sure if they did go out of state, but if they did, certainly they might be a good starting point. But yes, Massachusetts, because they have at least the ability to bargain, we can find out the extent to which it's been used. They're a little bit smaller agricultural economy than us, but they may have some insight, and their labor board could also talk about the experience of covering all collective bargaining rather than just agricultural.
And I think also that as we think about talking with labor and also farmers here, those people that we talk with may have recommendations regarding organizations or groups or advocates and the like who've been involved on either side of this that might be helpful in bringing just different perspectives.
Yep. Other thoughts?
Yeah, I'd like to hear from somebody in Maine, like if they had it to do over again, or, from the chairs of their ag committees or something, do they have things that maybe they pushed a little hard on something because they knew they could get it passed, but oops, the governor wouldn't go for it. And now in hindsight, what did they learn from their attempt to do this?
The governor wasn't why he vetoed it.
And then why did the governor veto it?
So we want to get both sides.
Exactly, exactly.
Yeah.
You said you posted the governor's.
I posted the governor's veto letter. It's, as veto letters go, it's relatively detailed. So there is some explanation in there of why she vetoed it. And it dealt, in my recollection, it dealt a fair amount with the burden on the smaller farms in Maine. So one of the answers might be, we should have put the cutoff at X number of employees, rather than at 5 where they put it. But who knows? But yeah, that they may also have some insight since they pursued it previously, and I imagine the Mills administration would also have some thoughts.
Sure.
So that gives us quite a bit, I think, to work on for next meeting. That's good. I wanted to just clarify too, the childcare and the independent care providers. So that conversation, Damien, if I understand it correctly, to the extent that they are or could negotiate with the state, it's not because they're employed by the state, but they're paid, they're reimbursed, or they receive some sort of payments from the state, and that's what they're negotiating over in that
Yes.
context, right?
They have limited collective bargaining rights, so we call them quasi-public employees because they're paid by the state, but they're employed by a private individual or a private childcare provider. So for the direct support providers, they're paid through the Choices for Care program under Medicare, and a couple other programs that basically provide home care for individuals who need help with day-to-day activities. So the employer of the individual is actually the person who needs the care, but the person is receiving the money to pay for the care through Medicare. And so they negotiate reimbursement. The providers negotiate reimbursement with the state, as well as professional development, things like that the state can facilitate. But their day-to-day working conditions are controlled by the person they're providing care for. And they have unionized. The early care providers never did form a union. The idea was that they could negotiate the reimbursement and professional development with the state. But then again, the operator of the early care provider would be there day to day. So it was one of these quasi relationships. But they never formed a union. There was a union drive and it failed in the initial year, and there's never been another attempt.
Anybody have anything else that you're burning to say before we sign off? All right,